Okay, good morning, everyone. So I'm going to start today's webinar before I hand over to Maryna. First of all, Happy New Year, and thank you for joining us at our STBB webinar. Today is going to be a great session, all about kicking off the year the way we should, and checking that everything is up to date and sorted, and that we know where everything goes in our business. So we're looking forward to this session with you. So before we start, my name is Leonie Steenkamp. I head up the marketing department at STBB, and we are very excited to be showing you today just a few changes that we've made to our website. So I just want to share my video with you. So just hold on. Let me sorry, it's not, there we go. So let me just show you, okay, can everyone see my screen? Sorry, let me just add. Great. So if you can everyone see can everyone see the STBB website? So as you can see, let me stop that for you. So if you scroll down, you'll see that we've added to our website all our media. So you are able to hear and see like all of our articles and our videos and our latest podcast. For those of you who are not following our podcast, please find them on the STBB Direct app so you can see our latest episode. But very important for those of you who are do actually join our webinars on a regular basis, you'll see that we've added a registration page to our homepage. So on all the you'll be able to see all the upcoming events that you can register for at STBB. So we're very excited to be able to share that with you. Without further ado, I just want to go through the house rules with you, and then I'll hand over to Maryna to take over today's session. So just remember to please keep your mics off, and please share your questions in the chat. Maryna will be dealing with them within an email. All of the chat or questions she'll be answering in email that we'll be sharing afterwards. If you have any queries regarding the webinar itself, as in the content, questions regarding that, you can reach Maryna on the email address compliance@stbb, but we'll be sharing that with you as well. And then also certificates will be shared. Please remember that it will be a certificate of attendance, so it won't refer to the word CPD because of the new changes on with the PPRA or the Property Practitioners Act. But you will be getting your certificate of attendance, and also you will be receiving the recording 48 hours after the session. However, we will not be sharing the notes with you, but we will, like I said, be addressing the questions within an email afterwards. So I think that really covers everything from my end. So without further ado, I'll hand over to Maryna.
Thank you, Leonie, and good morning to all, and welcome to our first webinar of the year. My name is Maryna Botha. I'm a director here at STBB Cape Town, and I employ most of my time between property matters, conveyancing, laws of compliance, amongst other things. And I am looking forward to sharing this 2024 planning with you. There will be some concentration on Property Practitioners Act, because we have a lot of estate agents that have entered the seminar for this morning. Sorry, I'm just trying to get my slideshow up. So without further ado, I'm going to just go over to slideshow, and then we can formally start. Share screen. Here we go. Okay, so we are going just to look at a practical point of view, what steps you can put in place now, March, August, June, to deal with all the facets of compliance. The main components that I will deal with are pieces of legislation, because if you look at the right-hand side of the screen, the law is the initial trigger of your compliance, and it might require you to draft rules, it might require you to draft policies or adopt standards, all of this which creates transparency, but the legal framework is where this originates from. And I'm going to look at POPIA, FICA, consumer laws, labor laws, taxation, Companies Act, Property Practitioners Act, in this session. As you can understand from that long list, we only have about an hour to deal with this. So I will be concise in my presentation. And for questions, as Liani mentioned, please use the sidebar, post the questions there, and I will address them and we will share it with you, as Liani said, within 48 hours, the answers there too. So probably by Monday, and then I can deal with most of the questions. As this quote says, it takes less time to do things right than to explain why you did it wrong or to explain away why you shouldn't receive a penalty as a result of non-compliance. And in this regard, I just want to mention that compliance has become a bit of almost a nasty word, and people say, I can't do this, it's too much red tape. And that is partly true, but because it is something we cannot get away from, perhaps the best way to approach is just, you get on the Nike principle, just do it. Okay, so the first piece of legislation that is very important to deal with is POPI, the Protection of Personal Information Act. And I've broken up all our slides into a first part, what just briefly says, what is this law about and why does it apply to my business? And the second part of my screen is what is required and when. And that I will then put on a compliance template for yourselves that you will see after. But okay, POPI, what is it all about? We know it has to do with protection of privacy rights of persons, actually of entities as well. It's a constitutionally entrenched right, and it's very, very important, therefore, to comply with it as a business. How is this achieved by the legislature? In this act, it prescribes rules for the gathering, the use, the storage, the application of information that you as a business collect. Unfortunately, and unlike many people believe, there is no one size fits all. One entity works with paper records only, another one works with online records only, one has ongoing clients. A hotel might, like a hotel who's got recurring clients. The other one is a restaurant who has takes details of clients who book places, but it's only for that once. So every business differs dramatically, and you have to take the POPI Act, which is an umbrella type act, and find the applicable rules and make it applicable to yourself. POPI is linked to PIA to a certain extent, and I will just touch on that and explain the differentiation in the next slide. And then perhaps just a note on case law. There's not been loads of cases dealing with POPI, despite the drama that associated its coming to operation a few years ago. But there's loads of cases dealing with privacy. You probably remember there was one last year that actually was quite interesting, of these mountain bike riders whose route passed through a farm, and the one guy saw the cages, certain cages, animal cages on the farm, in which there were dead animals, dead baboons, and a dead another one, and he was quite shocked about these circumstances. He took a photo, he took it to his he took it to a friend that he has who works at a charity organization looking after animals, They published it on Facebook, the photo, the name of the farmer, a photo of the farmer that they got off Facebook holding his little child in his hand, and even the telephone number of the farmer, the owner of the farm. And obviously that resulted in nasty legal transactions. In the first court, the claim of the farmer that his privacy rights were stampeded on actually was successful, and on an appeal it was overturned, the court saying, listen, you do have the right to privacy, but there was also a right to freedom of expression, and the public interest in this matter weighed so heavily that the right to privacy had to give way. So it's always a bit of a challenge between these rights, but they are exceptionally important and do reach courts in this way. And you also deal with client information quite often. You might share details of a client with another agent, or you might comment to a seller about a purchaser's behavior or action or conduct. Be careful, because privacy rules apply. The trigger, what makes it a fact that you have to comply with POPIA? The trigger is that POPIA says every business must comply if you process information. In other words, process is defined to mean if you collect it, if you store, if you use it, if you archive it, if you actually delete it. All of those actions with regards to information that you have, that is considered to be processing. So if you process data, you have to comply with this act. There's certain exclusions that we mentioned in the notes: personal household purposes, journalistic research reasons, and the like. But generally, for yourselves as business owners, you definitely have to have POPIA compliance in your business structure. So what is required then? Firstly, you have to have an information officer who's been registered with the information regulator. In terms of the act, they say the most senior person in your entity, in your business, is by default the information officer. Otherwise, you have to appoint someone internally, but that registration has to happen at the information regulator. This is not just a registration requirement. The nomination of information officer means that that person takes certain responsibilities in respect of the business onto himself. So he has to check compliance. He has to have made sure that there's a policy in place. He must address queries from the public and the like. But it's quite a long list. The other thing that you have to do now that you know that you have to comply with POPIA, you have to check operator contracts. That's third parties who you use to do certain functions for you, and in that role you give some information that you hold to them. For example, a third-party operator that pays your staff salaries. You will give the staff details to that operator. You will give the ID numbers, banking details, and the like. That's an operator. There's obligatory contracts that you have to have into place with persons like that. Then you must have privacy policies. There's two types I usually distinguish. The one is inwards facing. In other words, what you do internally in your office regarding data. I get sellers and buyers data. I get tenants, landlords data. Where do I store it? How do I store it? Who's got access, and the like. So you have a policy dealing with that. And then you have to have an outward facing policy to the public so that they know in which you state, this is the rules, this is what we do in this firm, in this business, this is how you can access information, you're allowed to change the record that we have of you, and the like. The inwards-facing document, obviously, you must have in your internal office records. The outward-facing document you must have available for people to inspect, or otherwise have it on your website as a link. Most people have it at the bottom of the page at a link. What you're also supposed to do is you have to reassess your compliance with POPIA. Is it successful? Is it not? Are your staff complying and the like? And the policy document that you will draft, your inwards-facing policy document, will have a date that say, listen, I've created it on 25 January 2024, and we will revise it again in a year's time. If you have that document, diarize that date in which you have to revise it, and then revise it and keep a record of it. Because if the regulator comes to you, they want to see that you followed your own policy, you followed your own rules regarding reassessment. Staff training is obligatory as well. They need to know what POPI means. They need to undertake to adhere to it. It's not good enough if you have a policy that's pretty and it's on your website and it's internal in a file, but your staff don't know what they're supposed to do. So the regulator wants to see proof of staff training, updating the documents if there's legislative changes, and if any new staff joins, that they receive an update of your business's POPI process. And then obviously you need to address your website to upload the necessary, and you need to also make sure that you've got internal records of your policy, your training, your updates, and the like. So this is our compliance diary, and after each act I will add to it so that you can see at the end of our talk today exactly what your year looks like. But for starters, now in January and February, make sure you've got an appointed information officer. Make sure that you review your existing policies if the existing policies had a reassessment date. And if you haven't done that yet, compile a new one. Then all of this is ongoing because you will work with this policy throughout the year, but you also must have, say, by September, have proof of staff training and have record keeping of the staff training that you've done. And maybe by October, you do a reassessment of your current progress in this regard, just to make a note, yes, we've assessed it, it's working for us, we're happy, and put that in your file. If your reassessment date is only in 2025, then obviously you will diarize for that year and not in this year, but diarize it and put it on your compliance diary. Okay, now let's go to POPIA. Again, that's the Promotion of Access to Information Act. It deals with consumers' access to information held by a private entity or a public entity, or by businesses, because persons, in terms of our law, are supposed to have access to information if they need it to forward a legal matter, for example. And the entity then cannot, without more, say, listen, I'm holding on to this because POPI says I have to. There's ways and means in terms of POPIA, how that person can nonetheless access those records. So in this sense, POPI and POPIA are two sides of the same coin, flip sides of the same coin. POPI says, collect personal information in the matter prescribed in POPI, safeguard it, deal with it very carefully. But in terms of POPIA, persons can at times have access to those records, which they otherwise wouldn't have had, but then POPIA rules apply. Now, oh yeah, and I just want to mention something here for interest sake. Where does PAJA fit in? Because one gets very confused with all these acronyms. PAJA is the Promotion of Administrative Justice Act. So it's a different one from POPIA, and that one deals with administrative actions taken by bodies where they make decisions which are either unlawful or unreasonable, or that the person has the right to dispute how that administrative action took place. But we're not talking about that now. We're only busy in this talk with POPI and POPIA. Okay, what's the trigger for POPIA? Why am I saying it applies to your business? Because the Act simply says so. Promotion of Access to Information says that you are a business private business holding information. POPIA applies to you. So what? the effect of this is that you must have what they call a POPIA manual, in which your business says, we understand that we are obliged to comply with POPIA. This is how the system in our office will work. In the past, up to July 2022, smaller private companies were exempted from the requirement to have a POPIA manual, but obviously that exemption has now been lifted, and every private company, private business must have a POPIA manual. Often that appears on the business's website, but if it's not there, they must have a record of it internally. You must also have a POPIA officer, and the default position, again, as with POPI, is the senior person of the business. Otherwise, they can appoint another person to fulfill that position. And POPIA otherwise includes the requirement, as I've mentioned, to publish the manual so that the public has access to it, and to refer or have copies of a document that the information regulator prepared in all the 11 languages of South Africa, that explains a person's right under POPIA. So your POPIA manual plus a link to the translation or the actual translations in that document. So, having said that about POPIA, what must you do as a business owner? You must ensure that you've got an officer appointed and someone dealing with the requirements of the POPIA officer that the Act prescribes. And the POPIA officer and the POPI officer do different functions. They're not the same, and don't confuse them. But if you in your firm have the same person doing both, make sure that the person understands the different duties lying on his shoulder in respect of the one and the other. The other thing you have to do is compile your POPIA manual or update your current one if necessary, publish on your website, or have a copy available. Advise your staff that you have such a manual, what it means, so that when they get queries from business or from clients and individuals from outside your business, and they say, I need details of a transaction or of a person or the like, what to do, what they must do to get access to those records. They must advise that person, listen, here's our POPIA manual, follow the steps therein and submit it to us, and we will then reconsider your request. Also, same as with the previous, if you get new staff or if there's legislative changes, you need to update your document, or you need to advise them of the existence of this manual and give them training. Also, similar with POPIA, reassessment. If your POPIA manual will perhaps state, we will reassess the details herein every 2 years, every 5 years, diarize that so that reassessment occurs and that you've got a record on your POPIA file that you have done the reassessment. Okay, so our compliance diary, I've now marked under POPI the month that is very important. Under POPIA, perhaps in February, you will appoint your officer if you've not yet done so, or update the officer's detail if there's been a change. Attend to your manual, either draft it from scratch or have it drafted, or reassess the current one. By March, make sure that all of this is updated to your website together with the translations. By April, make sure you've informed your staff of the meaning thereof and what to do if they receive a request from an outside person for information you keep that is private. And then on a continuing basis, monitor compliance, make sure if there's staff changes that they're alerted to it, and if there's legislative changes that you amend your documents. And then again, towards the end of the year, whatever your reassessment date is, make sure you've diarized it for the next year so that you can look at that in that year. Okay. Next one. Labor laws are very, very important, as we all know. And often I think most of your automatic subscriptions and deductions are attended to by your accountants. But let's just look at it from a compliance point of view. Your trigger, obviously, is if you have employees who are remunerated, you have to comply with our country's various labor law provisions. What does it mean? What's the effect thereof? According to our firm's head of labor law, James Foxcroft, he said that what the inspectors, when they knock on your door, ask for is firstly to see updated employment records. And in that sense, legislative updates must be annexed or added by way of addendums to the agreements. For example, the recent judgment, you would have seen it towards the end of last year, regarding the leave for also given to a father when there's a new baby in the family, paternal leave. It has to be included in the standard conditions of that contract, perhaps by way of an addendum. And for that purpose, it would be very good to speak to a labor law expert that they can provide the necessary to you. Then make sure what the inspector otherwise will check to make sure that you registered with SARS, that you've got UIF, SDL, and the POPIA subscriptions as required. And then they want to see your basic summary of the Occupational Health and Safety Act, which must be visibly displayed somewhere in your business premises or where your employees work. And then they want to see that you are monitoring the administrative actions and conduct of your employees, and especially what do you do? What are the steps that you take when you have new employees? And just a short point here, POPIA is also applicable in the labor law context because internally, the records that you keep of your staff, your employees, the CV, the proof of address, the mother's name, the medical aid details, whatever you keep, the records you have, obviously POPIA applies to that as well, even though it's internal with you, and you cannot just give it out to other people without that employee's consent. So even if a new employer phones you for a reference, you need the employee's consent that you can share certain records of that employee with that other prospective new employer. Okay, so what to do in your business? The main thing here is just to ensure that there's adherence to the SARS, to UIF, SDL, and the like, and that you have processes in place when a new employee joins your business, and also that you have your UHASA summaries displayed somewhere. So plot this on your compliance diary. For example, we know under labor laws, we've done POPIA and PIA. February, perhaps have a relook at your employment contract, see if addendums are required and arrange the necessary. Then ensure or just check that you've got updated UIF, SDL, COIDA, and the like. And then note that POPIA is obviously applicable. Speak to your internal departments and let them know, your HR department, let them know about the care that they must apply to the information they have of the employees. And then the requirement to deal with new staff, to the administrative process. Perhaps it's valuable to have a small policy document saying, if I get a new employee, I will do the following. 1, get his details safeguarded here, discuss POPIA with him, make sure he knows about PIA and the like, and just have a small document like that. And then every time a new employee joins, make a record that I've spoken to Joe and I've spoken to Sandy, and put a date there. But the labor department and their inspectors like to see a record of you having done something rather than you saying, yes, I did. Confirmation in a proper record is always preferable. Okay, let's go on. Companies Act. I'm dealing with Companies Act specifically because very many, or a large proportion of our businesses and your business are incorporated as companies. And in terms of the Companies Act, there's actually quite a few things to remember. The trigger for compliance, the trigger why it is here is if you are incorporated as a company, these rules apply, and you have to be aware of it and work it into your compliance program. What's the effect? Governance and fiduciary obligations exist. You must know what they are. You must train your directors on what their fiduciary duties are. Sometimes firms decide to take out director liability insurance, they take business insurance, but that comes with your governance and fiduciary obligations from the Act, and those are considerations that your board must take into account. Another thing that is brand new or fairly brand new towards the end of last year, you must prepare a beneficial owner register, and that has to be submitted to CIPC before your annual return. And according to, what is a beneficial owner? You would have heard a lot about that in the past few months regarding in a FICA context, but in the Companies Act context, they say that it is a person who either owns the company or who exercises de facto control of that company. And they say that anyone in a company who has 5% beneficial interest must be noted in this beneficial owner register. So they're looking for the owners of the company, they're looking for the decision makers, they're looking for the persons who's got veto rights, and anyone who's got a 5% or more share in those type of rights must appear on the beneficial owner register. It's a new requirement that is obligatory since October, November last year, and has to be submitted to the SIPC before you submit your annual returns. The SIPC notice regarding the beneficial ownership specifically stated that start soon because it is a long process, says the SIPC themselves. So do take care to start addressing that sooner rather than later. The other effect of having to comply with Companies Act is obviously submitting your annual returns and financial statements to the SIPC timeously. And then, yeah, those are the basic things that you'll see we've mapped on your compliance program. Just want to touch on small things. Trading as, if you have a company, registered company, but you are trading as under a different business name, there were some confusion as to must the business name also be registered in some other way with SIPC, because the Consumer Protection Act has a provision that requires such registration. But oddly, you know, the drafter of the Consumer Protection Act and CIPC never chatted with each other. And when this was made known to CIPC, they said simply they don't have capacity to deal with this additional registration. So at present, there's no obligation to do so. But you do run a risk because your trading as name is not registered anywhere and carries no protection. So if someone else opens a new company, registers a new company, and they use that name and register the name as such, you might lose that business name that you have. So it's a good idea that if you're trading as under a different name, to change the company name so that you don't have to have trading as. The other thing also, negative part of trading as, is that you have to mention this on all your letterheads and stuff. It just makes it cumbersome in some instances. I just want to also bring to your attention, CIPC were very, very busy over the past 3 months. They're always busy, but also after the past 3 months. And they issued notices to say they are, in the first week of February, going to deregister loads of entities who's been marked as not sending the annual returns for the past 3 years, and those will now be removed from the register. Many businesses and many business owners have various companies in which they have traded or used for different parts of their business. And sometimes it happened that they concentrate all of that in one without dealing with those other entities who were in their mind dormant, not really active anymore. Check the status on CIPC, check if you're at risk of being deregistered if you want to keep those companies alive. Otherwise, be aware that they will be deregistered in the first week of February. Another thing Companies Act related is your financial statements. Do you require an audit? Do you require a review? Do you have an exemption as a private owner managed company? Make very, very sure which of the above you need, because either option carries certain risks if you don't have no review. But if you're required to have a review and not an audit, it's cheaper to do the one rather than the other. On the other hand, if you have to have an audit, you need to know so that you can appoint your auditors and keep them updated of requirements. Another note, and this deals with your CIPC, keeping your records there updated. CIPC mentioned also towards the end of last year that they've got a new system, a multifaceted authentication process where there's amendments to directors. So director changes, apparently a more cumbersome process. So when you have director changes, just be aware that it might take you longer than before. But it's important that all details as registered with CIPC must be updated as they change in your business. Okay, so let's go back to our compliance diary. What is required and when? You must work back from your business's year end, which is usually relates to your incorporation date, and the anniversary of that would be your year end. Sometimes companies change their year end to fall on the fiscus financial year end at end Feb, but whichever your end of your year end, make sure that before that time you've done your beneficial owner register on the CIPC website, that you've instructed someone to start with the annual return, to get your financial statements, to start providing them. And in this regard, there's loads of detail on the CIPC's website and lists of what is required. So it's a matter of diarizing it and then implementing your diaries. Also, you will know that your tax due to SARS calculation will relate to your books as at the end of Feb of any year. So in principle, the books must be signed off every year at the end of Feb and restart at March. Take note of that for financial management purposes. And then as a small note on the side, what people sometimes forget, and what a legal due diligence type investigation will ask you for also, is your governance structure. It's important to see, is your management body keeping proper records? Are the meetings minuted? Are resolutions signed by everyone? Is the director's conduct appraised in some or other matter? Do they keep adequate records or not? So although it's not a diary item so much, it's a governance item, make sure that as part of compliance, you have a tick box there that it's on your list. Okay, so for companies, I've divided it in two, because on the one end, in the February, you know that books close because that's the end of the fiscus financial year, and thereafter tax will be calculated. So it's a time to speak with your auditors or your accountants and arrange the necessary with them. On the other hand, depending on the business's year end, get that beneficial owner detail to CIPC. Start preparing the annual return, tax return, and financials so that at least 3 months ahead, so that you can submit it to CIPC at your entity's year end or within 30 days thereafter. So the annual return preparation would not necessarily start in February, but I use a 3-month period just to start diarizing and advising clients of what to expect within 3 months. If your year end is August, you need only start, for example, in May. Okay. Now let's go further. Your diary is filling up. Consumer protection. We know, and we've trained and heard seminars about consumer protection for many years now. The Act came into with a big noise and boo-ha, and we haven't seen that much of it since. Nonetheless, what it is a very overarching, one-size-fits-all type act which sets out how businesses must deal with consumers in business transactions and the rights that consumers have vis-a-vis those businesses. There's limited exclusion, but generally, if you're a business, compliance is triggered by the fact that you render a service or deal with products vis-a-vis consumers. So state agencies, managing agents, property practitioners generally have to comply with the CPA. Okay, so what's the effect of this fact? Loads of small things, and again, things that really don't have dates attached to them, but compliance is obligatory nonetheless. Contract terms need to be updated to make sure they are in plain language, to make sure there is no unfair, unjust, unreasonable provisions, to make sure that onerous provisions are highlighted, brought to the attention of the consumer. In our STBB property law update, 2 weeks ago, there was a judgment that we referred to in which the persons were fighting whether or not a suretyship signed by one person was valid or not. And the court, in discussing that document, actually highlighted the fact that the document signed by the person who's now trying to avoid liability had highlighted clauses drawing attention to them. So it's a practice, it's accepted practice, it's a good idea, it's obligatory to do so under the Consumer Protection Act, and make sure that your contracts are reviewed for that if it's not already there. Then remember, the Consumer Protection Act prescribes that your business details must appear on marketing and other material that you use in your business. You must know and include in your agreements, because the Act asks you to include the rights in the agreement where consumers have the right to walk away from a contract that you have negotiated with them in specific circumstances. And you need to address and align your marketing plans and your marketing methods with the marketing rules in the Consumer Protection Act. There's loads of them. There's loads that deal specifically with direct marketing and what it is and what it isn't, but you have to align the two, get advice on it, but make sure you comply. And when are you supposed to comply with this? Actually, since 2011, when the Act became fully operational. So what I would add to my compliance diary is simply review your agreements, review your marketing strategy, your business material, inform employees in your business of what their role as an employee of this business is vis-a-vis consumers, clients, and what they must respect, what they can expect, what the client may expect of them. It doesn't help that you as an owner or are aware of the principles of POPIA, but your staff has no idea. Have a process or draft a process and train someone to deal with consumer complaints. They arise actually quite a lot, especially in the range of direct marketing. People are angry. They say, how did you get my email? How did you get my number? You're not allowed to do so. Whether they're right or not, you need to have a method of dealing with this. And then monitor your own compliance. So if I plot this on my on my diary under CPA. I've marked it as something that's quite continuous. It's definitely necessary. There's no particular due date, but the sooner it's done, the better, and the sooner you know that that aspect of your compliance has been dealt with. CPA, you can see, is the third from the right. The others I've now just marked by crosses and didn't mention the specific items. Okay, taxation, very little elbow room, as we know. As a business owner with employees or running an enterprise, you have to register with SARS. You cannot register your company even if you haven't registered with SARS. So the trigger for compliance is obviously the fact that you're running a business, and the effect is that you must look at the tax laws and adhere to SARS requests. Often practitioners do get tax practitioners to help them, or attorneys specializing in tax if there's questions, but you do get a lot of guidance from the FICA website as well as to what a business should do. From a compliance point of view and a diary point of view, I want to just briefly mention or note there your FFC requirement that for a state agent that says in your 3-year cycle, by October 31 of that 3-year cycle, you must have applied for your new FFC, and as part of that application, the business must provide a tax clearance certificate, and therefore plan it in your books, put that date 3 months in advance of 31 October, so that you can start then already with asking your accountant or yourself, applying to SARS and seeing if everything is in order for you to have that clearance so that you can submit your application in October. And then obviously your fiscal year end, at end of February, companies must close books so that the tax calculation can be made as to the tax owing to SARS, and then the books will reopen on 1 March. Diarize that so that you liaise with your accountant in that regard. So under taxation, tax affairs, fiscal year end, year in Feb, you will liaise with the accountant, and the new year will start in March. And for property practitioners, if the requirement is to apply for the new FFC in this year, diarize 3 months in advance to start working on your tax clearance for the FFC. And otherwise, you will always plan for the fiscal year end, and for your company at year end, we mentioned on the Companies Act slide, but this is what you would have to just space on your plan, on your compliance plan. Okay, let's see Property Practitioners Act. We are very familiar with that, and because many of our participants today are property practitioners, I decided to include it here. We know that we have to comply with the Property Practitioners Act because we fall within the very broad definition of property practitioner in that act. There's nuances. Sometimes it requires that the business only comply with certain provisions and carry a FFC. In other instances, it's the business as well as the practitioners. But that is the trigger, that definition of property practitioner. What's the effect? What then, from a compliance point of view? We know that record-keeping obligations exist for 5 years, so make a note to check that that is in your system. Agreements need certain wording. Disclosure forms must be attached in certain instances. Or accounting records must be available to be submitted for inspection by the new regulatory authority, and email communications I mentioned there simply because they must also have certain prescribed documentation. So the business must ensure also, in addition, that the prescribed qualifications and ongoing training requirements of the relevant staff are adhered to. as and when the regulatory authority give guidance in this regard. They are often changing what type of training and training that property practitioners must undergo in a year and the type of record they want there. But as business owner, you need your staff to be compliant and need to check that these activities are happening. As a business owner, ensure your letterheads are correct, your marketing materials has the prescribed wording, and that your agreements are compliant. The regulatory authority are exceptionally strict on that and require almost compliance to a T. If their letter didn't have a capital where it was supposed to have a capital, they actually want you to have it incorrect in your document as well, almost to that extent. Yeah. And then obviously valid FFC for the business and for the property practitioners, the staff who are required to have that, ensure that it's there. Okay, so from compliance point of view, what to diarize? Diarize your application for the FFC and 3 months before, start working on the BEE certificate or affidavit that's required for that application in October. Start speaking to SARS or your accountant for the tax clearance that you will need to submit as well. Make sure that if there's been any name change of your company, that's sorted so that you can, well, you should have advised the regulatory authority of that as soon as possible, but have your paperwork in order so that the due date doesn't scare you or fall on you when you're not ready for it. If you have a trust account, the bank must yearly submit a declaration of interest to the regulatory authority. So make sure with your accountant that that's done and make a diary entry as to when you will check that, that it's been done. Diarize your instruction for an audit review of financial records because you need because you're obliged to do that for purposes of any FIC inspection. Plan your fiscal year that occurs in Feb. And for inspections from the FIC, make sure that you've got a 5-year record-keeping system in place and general compliance, I mentioned there, verified that the prescribed wording and the like are in your documents. Okay, so what does this do to my diary? PPA, general compliance with the stuff that we mentioned, updating of documents, looking after compliance of your staff, but also towards the time of applying for FFCs, make sure that 3 months before you start with your tax clearance, you start with a BBEE affidavit or application, and so that by 31 October, if that is your year for application, that you can apply without being under too much pressure. Lastly, let's touch on FICA. We are going to run out of time, but this is the last one we're going to deal with, or second last slide. FICA, we know the trigger is if you're defined in that act as an accountable institution. Many organizations fall within that description, ourselves as attorneys, yourselves as property practitioners. So FICA becomes very, very important for you. By the way, though, and when you speak to colleagues in other industries, every business in South Africa is obliged to report to the FIC whether or not they are accountable institutions if they're aware of or encounter unusual or suspicious activity. There's a special place on the GoAML website for that, for non-registered entities. But the fact that you're not an accountable institution doesn't mean that you may overlook unusual, suspicious transactions in the sense, obviously, of potential money laundering activities. Okay, so FICA is pretty much self-explanatory after the drama last year, but you have to appoint a compliance officer. You have to be registered with a FIC. That's a compliance aspect. You have to have an RMCP, risk management and compliance program, and important for this year specifically, If your RMCP that you prepared last year say that you will revise it every 6 months or every 12 months, then it's likely that your revision date falls in this year. Make a note, and then on that month, if it's October this year, make a note in your diary, revise RMCP, and then sit down, revise it, and have a record of, I sat with my partner, we revised it, we're happy with it, or we changed it, and put that in your FICA file. Don't forget to do that. Then also on a compliance point of view, you remember that there's a provision that if you have ongoing clients with continuous transactions, such as a continuing landlord that instructs you over years to find tenants for a property, you have an obligation every now and again just to check if things are still the same. That's part of the ongoing due diligence for business relationships. So if in your RMCP, you said your ongoing due diligence will happen with 6-month intervals or 2-year intervals, diarize that for this year or next year so that on the relevant date, you can attend to that. Another thing, just as a highlight, towards the end of last year, the FIC said, apart from scrutinizing all your clients against the list of known terrorists, you must also scrutinize senior people in your business, your directors, your office manager, your financial manager, have to be scrutinized against that list. So make sure that you have a date and a time yearly or 6 monthly where you run all your senior staff against the TFS list, keep copies and keep that in a file. And then your continued staff training on FICA is hugely important. So diarize that and do the training, keep a record of the training and diarize it now so that you know I'm going to do it then and I'm going to do it then. The other thing to do from a FICA point of view is to ensure that you report, that your reporting duties are complied with and that there's record keeping. But that means your FICA compliance officer has a lot of work, and as business owner, there must be a checklist for that FICA officer just to see. That checklist can be 6 monthly or 2 monthly, where he says, listen, I have been monitoring transactions, I have been reporting as necessary, and I'm happy with progress and the like, and file that in your office. Just that you've got that check in place. And that will bring your screen looking like this, where you just diarize what you're going to do with regards to FICA. In our, what we send back to you, we will share this basic screen with you so that you have this to use for your own preparations if necessary. My last slide, I just want to mention briefly that fear-mongering has become a big thing. And people, I get so many calls from clients saying, I've just read this, and they say we're supposed to have that, or I must have done that, and I should have done more or less, or I did this wrong. Don't fall for that. Just work with someone you trust, that's knowledgeable, have adequate internal or external assistance, and you will be updated of the necessary compliance requirements. This fear-mongering, this stress, this drama is really, really unnecessary. The point with all these acts are to create transparency and to move towards a be it final result where people are used to being compliant. And the point of compliance is there's never an end point. It always changes. So you will always be working towards a better version of what you've got. The authorities who apply the rules simply want to see that you have rules, you've got a mechanism, and you are implementing it in your office, and you are addressing shortcomings. That's the gist of it. There's here and there's strict requirements like the TFS list and registration with the regulator, but those are easy things to comply with. They're not so difficult. I want to invite you also to contact us at compliance@stbb.co.za. If you want to receive our monthly compliance alert, it's just an alert of anything that has changed. If nothing has changed, we will confirm nothing has changed. This has been in the news, that has been in the news, take note. Or you need to look at a change that's coming in July or November this year. But in that way, you will always have an automatic alert. And then another note, third-party assistance. Do you have to do all of this internally or externally? Internally is usually cheaper, perhaps, because incorrect compliance can cost you. But it usually, if you have a capable internal person who can deal with all of this, and all of this, if you look at the previous slide, is quite a lot. It's loads of things to keep in the basket without letting any of it fall out. If you've got an internal person who can do that, support that person, help him, but monitor compliance from that person's side, give him a list to work off, and it can definitely work, especially in small private entities. However, it's cumbersome, lot of things that change, and it might help you to work on a once-off basis with a professional person or over a period of 6 months, or have a monthly check-in with a professional person. It's a choice that you make for your business, but either or, both can work and can benefit you dramatically. We do, in our Compliance Hub, have specific structured offerings and payment plans for 12 months monitoring, as opposed to once-off assistance. So again, if you want to inquire about that, do contact us on compliance@stbb.co.za. Okay, that's me for today. It's been lovely to meet you and to start the year on a good note. I hope it's not scary, and rather that it's very doable. Now that you know how much there is to address, and in many instances, you will be halfway there already. So don't think it's something that you have to start from scratch. And you're really welcome to join us, ask us for questions at any time. Okay, thank you.
Thank you so much, Maryna. I see that we have quite a bit of questions in the box, so Maryna will get to those, I'm sure, after the session, and we'll include it in mail, so you will have those answers available. So thank you everyone for joining us today. We hope you enjoyed it. We would love to get your feedback on our webinars, and please remember to join us for our next webinar. We've added the registration link in the chat box, so you'll find it there. But please feel free to join us on our monthly webinars that we'll be hosting throughout the year, with valuable input and advice and tips and tricks from all our professionals and experts at STBB. So thank you once again, everyone, and I'm wishing you a lovely Thursday and a Friday and then a good weekend.